Hi, this is Lee from the Law School Toolbox. Today we will be discussing substantive criminal law. We're looking at crimes against another person, specifically homicide and felony murder. We've covered the basics of homicide in an earlier episode that we will link to in the show notes. But today we're taking it a step further and diving deeper into some complex aspects of homicide law that frequently appear on exams, specifically the felony murder rule and causation in homicide cases. If you haven't listened to the previous homicide episodes yet, you might want to start there for the basic framework. We have linked to it in the show notes. But today, we're going to explore some important nuances that can make or break your analysis on an exam. So let's start with the felony murder rule. At its core, the felony murder rule states that a death occurring during the commission of certain felonies can be charged as murder even if the defendant did not intend to kill the victim. Like murder, felony murder is 1, the unlawful killing, 2, of a person, 3, with malice aforethought. The distinction lies in what malice aforethought means. For felony murder, it means the defendant had the intent to commit an inherently dangerous felony, and that felony resulted in death. This means that even if the defendant never intended to kill anyone, they can be convicted of a murder if a death occurs while they committed a felony, provided the defendant meant to commit those felonies. You might be wondering which felonies qualify. Depending on the jurisdiction, there are different ways of analyzing this. Some use a list of enumerated felonies, while others consider whether a felony is inherently dangerous. The enumerated felony approach means the felonies that may be charged as felony murder are listed or enumerated. The traditional enumerated felonies are burglary, arson, robbery, rape, and kidnapping, sometimes called the BARK felonies, B-A-R-R-K, to help you remember them. Some jurisdictions add additional crimes like drug trafficking or carjacking to this list. Under the inherently dangerous felony approach, on the other hand, courts look at whether the underlying felony is inherently dangerous to human life. There are 2 major approaches that jurisdictions use to determine if the crime was an inherently dangerous felony. First and most common, the facts of the case rule. In this rule, jurisdictions examine the particular facts of the case to determine whether the felony was inherently dangerous. The second and less common approach is the in the abstract rule, which means the jurisdictions consider only the elements of the underlying crime in the abstract and ignoring the specific facts of the case. This approach focuses on the elements of the crime itself, not the particular facts of how the defendant committed it. For example, manufacturing illegal drugs might qualify because the process is inherently dangerous, while theft typically would not because it is not a threat to life. Now, let's throw in one more twist. The merger doctrine puts an important limitation on felony murder. Under the merger doctrine, the underlying felony must be independent of the homicide itself. In other words, if the felony is simply the means of committing the homicide, it merges with the homicide or becomes one act and cannot serve as the predicate felony for felony murder. For example, assault cannot serve as the predicate felony for felony murder because assault is typically part of the conduct that causes death. Let's also talk about the death of a co-felon rule. Jurisdictions are split on whether the felony murder rule applies when the person killed is one of the people involved in the felony. The traditional approach, called the agency theory, holds that felony murder only applies when the death occurs during and in furtherance of the felony and is caused by one of the perpetrators. Under this view, if a security guard shoots and kills one of the robbers during a bank robbery, the surviving robbers cannot be charged with felony murder. The proximate cause approach would allow felony murder charges in that situation, provided the death was a foreseeable consequence of the dangerous felony. You might notice that the proximate cause approach looks a lot like tort law. If so, good eye. Speaking of causation, that brings us to our next topic. In criminal cases, prosecutors must prove both actual cause and proximate cause. If the jury needs to find that a defendant caused the death of another in a homicide case, that means they need to find the defendant's actions were the actual cause, meaning the defendant's conduct was a but-for cause of death. In other words, the death would not have occurred but for the defendant's actions. But that's not enough on its own. The prosecution must also prove proximate cause, that the death was a foreseeable consequence of the defendant's conduct. Causation gets especially tricky in homicide cases where there are superseding intervening causes between the defendant's conduct and the death. A superseding intervening cause is a third party's act that occurs between the defendant's act and the victim's death. The key question is whether the intervening cause breaks the chain of causation, usually cutting off the defendant's liability for the death. To determine this, courts look at whether the intervening cause was 1, independent of the defendant's wrongful act, 2, unforeseeable. If the elements are met, the intervening cause breaks the chain of causation and the defendant cannot be convicted of homicide. However, if the intervening cause was a foreseeable response to the defendant's conduct, like the victim receiving medical treatment, it does not break the chain of causation. So let's work through some exam-style hypotheticals together to see how these rules play out in practice. Remember, whenever you're analyzing criminal law questions, you want to identify the issues, state the relevant rules, analyze by applying those facts to your facts, and reach clear conclusions. Here's our first scenario. Dan and Victor plan to rob a convenience store. They have a plan. Dan will carry a gun, but they explicitly agree it's just to scare people, not to hurt anyone. When they enter the store, it's more crowded than they expected. The clerk, Carl, reaches under the counter, and Dan, thinking Carl is going for a weapon, fires what he intends to be a warning shot into the ceiling. The bullet ricochets and hits a customer named Anne in the shoulder. While this is happening, Victor empties the cash register. Suddenly, an off-duty police officer named Paul draws his weapon and announces himself. Paul fires at Victor, but misses, instead hitting another customer, Bob, in the chest. In their panic to escape, Dan and Victor steal Bob's car. During the high-speed chase that follows, Victor loses control and crashes into a tree. Dan dies instantly. 2 weeks later, Anne, who was hit by that ricocheting bullet, develops a severe infection during her hospital stay. Despite receiving standard medical care, she dies from the infection. Bob, who was shot by Officer Paul, eventually recovers from his wounds. What crime can Victor be charged with regarding both Dan's and Anne's deaths? Discuss. There are a lot of characters and moving pieces here, so we need to break this down systematically. First, can Victor be convicted of felony murder for Dan's death? The rule for felony murder states that a death occurring during the commission of certain felonies is automatically murder, regardless of the defendant's intent regarding the death. Remember, however, jurisdictions are split on whether this applies to deaths of co-felons. Under the traditional agency theory, felony murder only applies when the death is caused by one of the perpetrators during and in furtherance of the felony. Under the proximate cause theory, felony murder applies to any death that was a foreseeable consequence of the dangerous felony. Breaking it down, we have a death that occurred during an armed robbery, one of the enumerated BARC felonies that can support felony murder. Alternatively, it is an inherently dangerous felony under the facts of the case approach, as Dan brought a loaded gun to the scene regardless of his intent to use it. And under the abstract approach, the elements of armed robbery, specifically the armed piece, indicate the act is inherently dangerous. The crash occurred during an escape phase, which is part of the commission of the felony. And Victor's actions were the actual and proximate cause of Dan's death. However, the death of a co-felon, Dan, was caused by the crash rather than by someone trying to stop the robbery. Under either theory, it is likely Victor can be charged with Dan's death. In an agency theory jurisdiction, Victor would be liable for felony murder because Dan died during and in furtherance of the felony. The felony was going on as the two engaged in the high-speed chase. Further, Victor, as the driver, caused the death, not a third party. In a proximate cause jurisdiction, Victor could also be convicted because a fatal crash during a high-speed escape is a foreseeable consequence of the armed robbery. The second issue, can Victor be convicted of felony murder for Anne's death? The rules at issue here are felony murder and causation. We have already found that Victor was engaged in an enumerated and inherently dangerous felony. We know Anne died after being shot by Dan during the felony. But did Victor cause Ann's death? For causation, we need both actual cause, which is but-for causation, and proximate cause, which is foreseeability. An intervening cause breaks the chain of causation only if it is 1, independent of the defendant's conduct, and 2, unforeseeable. The first question is actual cause. Was Dan's warning shot a but-for cause of Ann's death? Yes, if Dan hadn't fired that warning shot, Ann wouldn't have been wounded by a bullet and wouldn't have contracted the infection that ultimately led to her death. But what about proximate cause? For proximate cause, we need to ask, was the death a foreseeable consequence of the armed robbery? Well, let's break this down step by step. First, is a ricocheted bullet a foreseeable consequence of firing a gun in a store? Absolutely. Anytime you discharge a firearm, especially in an enclosed space with hard surfaces, ricochets are a foreseeable risk. But what about the infection? This is where it gets interesting, since both the gunshot wound and infection play a role in her death. Under the traditional rule, medical complications that arise during treatment don't break the chain of causation. Think about it this way. You cause someone to need medical treatment, it's foreseeable that something might go wrong during that treatment. The fact that Ann contracted an infection in the hospital doesn't change this analysis. Medical complications, even unusual ones, are considered foreseeable consequences of injuries that require treatment. But wait, Victor didn't fire the shot. Dan did. Is Victor liable for Dan's actions? As Dan's co-felon, Victor is liable for any death caused in furtherance of their shared criminal enterprise. We didn't cover accomplice liability in this lesson, but an accomplice can be deemed guilty if they participated in the commission of the felony and intended for the target felony to be committed, and a killing occurred as a result. It doesn't matter that Victor didn't fire the shot or that they agreed not to hurt anyone. Under the felony murder rule, when you agree to commit a dangerous felony like armed robbery, you're on the hook for deaths that occur as a result. Therefore, we can conclude that Victor could be charged with felony murder for Ann's death. The medical complications don't break the chain of causation. The death occurred during an enumerated felony, and co-felon liability extends to all deaths caused during the commission of the felony. Now let's look at another hypothetical that raises some different and fascinating issues about felony murder and causation. This one gets into some tricky questions about medical complications, multiple causes, and the scope of felony liability. So here's our scenario. Mike is a drug dealer who decides to rob his supplier Pete's house. He knows Pete keeps substantial cash from drug sales, and he figures the house will be empty since Pete usually makes deliveries at this time. Mike brings his younger brother Larry along to help carry whatever they steal. But things don't go as planned. When they break in, they find Pete at home with a customer named Steve. Pete reaches for what Mike thinks is a weapon, though it turns out to be just his phone. Mike shoots Pete in the leg, then grabs Pete's gun collection and the cash. As Mike and Larry are trying to leave, Steve attempts to stop them. During the struggle, one of the stolen guns accidentally goes off, hitting Steve in the chest. Meanwhile, Pete makes what turns out to be a fatal decision. Instead of calling an ambulance because he doesn't want police investigating his drug operation, he tries to drive himself to the hospital. He passes out while driving and crashes into a tree. At the hospital, doctors discover Pete has a rare blood condition that makes bleeding much more severe. Despite receiving proper medical care, Pete dies 3 days later from complications related to the leg wound and his blood condition. Can Mike or Larry be found liable for Pete's death? Steve's? Discuss. Let's break this down systematically, starting with Pete's death. The first issue we need to address is whether Mike and potentially Larry can be held liable for Pete's death under felony murder principles. The rule for felony murder, as we discussed earlier, is that a death occurring during certain felonies constitutes murder regardless of the defendant's intent regarding the death. We also need to consider our causation rules. Remember, we need both actual and proximate cause, and an intervening cause breaks the chain of causation only if it's independent, unforeseeable, and the sole cause of death. Analyzing Pete's death, we have several complex causation issues. First, there's a clear actual causation. But for Mike shooting Pete in the leg, Pete wouldn't have been driving to the hospital, wouldn't have crashed, and wouldn't have triggered the bleed that caused his death. But the proximate cause analysis is trickier. We have multiple intervening events: Pete's decision to drive himself rather than to call an ambulance, the car crash, and the previously unknown blood condition. So would a reasonable person foresee that shooting someone in the leg would lead to them driving themselves to the hospital and crashing? This is debatable. While seeking medical attention is certainly foreseeable, Pete's specific decision to avoid calling an ambulance due to his illegal drug operation might break the chain of causation. His decision was independent of Mike's conduct and arguably unforeseeable. Most people would call an ambulance for a gunshot wound, although perhaps not most drug dealers. The blood condition adds another layer of complexity. Under traditional rules, while unusual medical conditions of the victim generally don't break causation, you take your victim as you find them. Remember the eggshell skull rule from torts? This situation is different because the condition is combined with Pete's own decision to drive himself to the hospital. The condition on its own, however, does not break proximate causation. The court could go either way on this one, so it's a good opportunity for you to flex your legal writing muscle and argue your best case, showing that you understand the strengths of both arguments. Now let's examine Steve's death, which presents a cleaner felony murder analysis. The issues here are whether the accidental discharge during escape still counts as felony murder, and we still need to discuss whether Larry can be held liable for either death despite his limited involvement. Steve was shot during the commission of the felony, right in the middle of it, actually. The felony was inherently dangerous. Though they thought they would be committing a burglary, it turned into an armed robbery when Steve and Mike were home. Either way, burglary and robbery are both enumerated felonies in Bark and inherently dangerous, factually and in the abstract, as discussed previously. Now you might think, but the gun went off accidentally. In fact, it doesn't matter that the gun went off accidentally. That's actually one of the core purposes of the felony murder rule, to hold felons responsible for accidental deaths during dangerous felonies. Analyzing Larry's liability, although he never agreed to violence, he did agree to participate in a dangerous felony involving stolen guns. The fact that he didn't personally handle the gun that killed Steve doesn't matter. Once you join in a dangerous felony, you're liable for the deaths that occurred during its commission. Again, accomplice liability. This hypothetical really shows us how complex these cases can get when we have multiple participants, intervening acts by the victim, and medical complications. It's crucial to analyze each death separately and methodically, work through both the felony murder and causation elements for each defendant. That's all we have time for today. Keep reviewing substantive criminal law and practicing hypos, and soon you'll be able to crank out criminal law questions in your sleep. Thanks for watching. And if you enjoyed this episode, please leave us a like or a comment and subscribe so you don't miss any future episodes.